Hello, I'm David Fagan of EURep.ie. Welcome to this short video for non-EU businesses. We briefly explore the reach of EU data protection regulators and how the EU data protection regulation, the GDPR, can practically affect your business. As a non-EU business, your main liabilities when processing information relating to EU residents, whether that's in the course of a sale or the provision of a service, or whether it's by marketing or behavioural advertising, etc., are firstly, the legal basis for processing the information. Boiled down, this is simply that you have a valid and lawful reason to be processing this information. The default position in the EU is that information relating to individuals must not be processed at all. There are then a series of exceptions to this proposition. This video is too short to go into all of those exceptions, but you are likely processing on the basis of fulfilling a contract or on the basis that you have a legitimate interest. There are very significant restraints on what counts as legitimate interest. You're also required to keep information secure and to confirm to those individuals how you handle their information, what information you hold about them, who else processes that information on your behalf, what jurisdictions you transfer that information to, and the legal basis you claim for processing that information. If that legal basis is that it is in your legitimate interest, you must specify the nature of that legitimate interest. All of this is usually communicated in a privacy policy, often published on a website, and also in transparency notices given on order forms, sign-up questionnaires, and similar points of contact between the business and the individual customer or target. You're also required to keep a record of the type of processing you do, and if you transfer personal data out of the European Union, you are required to have some basis for doing so. This is often on the basis either of a standard type contract or alternatively by entering into the Privacy Shield scheme. Lastly, and very importantly, if your company or organisation is not established in the EU, you are required to appoint an EU representative who is established in the EU. Mostly the service is provided by specialist providers such as ourselves, EURep, but sometimes it's provided by subsidiaries. But the problem with subsidiaries is that they are often too busy, focused on their own specific tasks, and they may not necessarily have the skills required or the knowledge required for this data protection task. The easiest fix for non-compliance is to tackle the externally visible non-compliance first. These tend to be things like privacy notices, which are generally visible on websites, and all the regulator has to do is search for your privacy policy. Similarly with transparency notices, which are often visible on online order forms and the like. Another easy win for the regulator is to check whether an organization's website sets cookies, and let's face it, everybody does. And if so, to check that the organization has a sufficiently granular cookies policy, preferably with a dashboard enabling cookies to be thematically disabled. If a non-EU organisation appears to be selling into an EU country or to be targeting EU residents with advertising, this will usually be easily apparent from the organisation's website or electronic marketing campaigns. The European Data Protection Board and the European Court of Justice have found that having country-specific versions of a website, translations into specific EU languages, or even allowing purchases from an EU jurisdiction is a sufficient trigger to require the appointment of an EU representative. Once the externally visible compliance has been resolved, the organisation can again move to tackle less visible compliance problems such as putting in place appropriate internal policies for employees, privacy impact assessments, contractual documentation, retention policies, data minimization policies, IT policies, etc. Non-compliance can be discovered here too, but it is less visible to European regulators. You can, however, still get caught out. Data breaches are problematic for non-compliant organizations. Every organization has data breaches. However, when an EU regulator investigates a data breach, they typically ask the organization to provide a copy of the minimum documentation that they would expect the organization to hold. This will be, at the very least, the following: a privacy policy and any transparency notices, a record of processing, this is a document showing the processing that the organization does, the IT security policy, and for non-EU organizations, the regulator will also want to know who the EU representative is. In fact, the EU regulator will look for the EU representative before it does anything else, as it will normally contact that EU representative as its first port of call and seek all of these documents from the EU representative in the first instance. If you do not have an EU representative, therefore, the regulator will already be aware of a significant breach of the GDPR and will be ill-disposed to the organisation from the start. A data breach can come to the attention of the regulator because of publicity reaching that regulator, or because the organisation feels obliged to report the breach to the regulator itself, or because an EU resident, a data subject, reports the breach to the regulator. So what can go wrong? Surely my organisation is protected by virtue of the fact that we are based outside the EU. For instance, if I am a US organisation, surely the EU GDPR regulation cannot have any practical effect for me. Well, yes and no. It is true that it is difficult to enforce regulatory decisions across jurisdictions. However, the fines under GDPR are very substantial, and an organisation which ignores them has to take certain risks. Most important of these are customer issues. Many customers, particularly corporate customers, require confirmation of compliance before they do business with an organisation. This also frequently occurs in due diligence on sale or merger. Concern about GDPR issues in Europe is high and is often a significant factor in choice of supplier or business partner. It's also the case that there is personal criminal liability in some jurisdictions in the EU for breaches of data protection legislation. This can extend to directors, managers, and other decision makers in an organisation. Where the criminal penalty is a term of imprisonment of 1 year or more, a European arrest warrant can be issued. In such circumstances, the arrest warrant can be executed not only in the country which issued the penalty, but also in any other country of the European Union. Although the risk of this is moderate to low, it could be a very bad start to a European holiday for an executive to be stopped on entry to the EU on foot of an outstanding warrant issued in another EU country. So what are the solutions to compliance for a non-EU company? Firstly, tackle externally visible non-compliance first. This makes sense as externally visible non-compliance is a red flag to regulators. These are things like externally facing privacy policies and transparency notices, giving some indication of a retention policy, making sure that a cookies policy is up to date and compliant with the GDPR, and most importantly, appointing an EU representative who will be the point of contact between an EU regulator or EU resident and your organisation in the US or other non-EU jurisdiction. After you've done that, move to tackle externally non-visible non-compliance. This may be more extensive, but is less visible to regulators. So if you are appointing an EU representative, please contact us on www.eurep.ie or info@eurep.ie by email. If you require other assistance, our sister company Business Legal will be pleased to support you. They are at www.bizlegal.eu. Many thanks for watching, and I hope this has been informative.